Be ready. Start. The introduction and acceptance of public interest litigation as a jurisprudential concept is a matter of extensive debate in India and even more than that outside India. This concept brings into focus the rights of the plurality as against individuals' right, especially when the plurality is for one or the other reason not in a position to seek redressal of its grievances. This inadequacy may not always emerge from financial constraints. It may sometimes arise out of lack of awareness, at other times merely from the overwhelming might of executive authority. The jurisprudential thought in this country, after the emergence of public interest litigation, is seeking to strike a balance between individual rights and the rights of the plurality. After all natural resources are the nation's collective wealth. This court has had the occasion over the last few decades to determine rights of citizens with reference to natural resources. The right of an individual citizen to those assets as also the rights of the remaining citizens of the country have now emerged on opposite sides in a common litigation. One will endeavor to delineate the legal position expressed in decisions rendered by this court on issues relatable to disposal of resources by the state to determine whether the instant issue stands settled by law declared by this court. In this context, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law upon which our whole constitutional system is based. In a system governed by rule of law, discretion, when conferred upon executive authorities, must be confined within clearly defined limits. The rule of law, from this point of view, means that decisions should be made by the application of known principles and rules, and, in general, such decisions should be predictable and the citizen should know where he is. If a decision is taken without any principle or without any rule, it is unpredictable, and such a decision is the antithesis of a decision taken in accordance with the rule of law. In the aforesaid case, it came to be emphasized that executive action should have clearly defined limits and should be predictable. In other words, the man on the street should know why the decision has been taken in favor of a particular party. What came to be impressed upon was that lack of transparency in the decision making process would render it arbitrary. A perusal of the observations made by this court reveals that the government must act as a prudent businessman and that the profit earned should be for public benefit and not for private gains. A plea of reasonable restriction raised under Article 19(6) of the Constitution of India to save the governmental action was rejected on the ground that the scheme created middlemen who would earn large disproportionate profits. This court also held the action to be discriminatory because it excluded others like the petitioners from the zone of consideration. Finally, a direction came to be issued by this court requiring the government to act in the interest of the general public and to invite tenders so that the state may earn the entire benefit in a manner that no disproportionate profits are diverted to any private agency. An analysis of the aforesaid determination by this court would lead to the inference that the state has the right to trade. In executing public contracts in its trading activity, the state must be guided by relevant principles and not by extraneous or irrelevant consideration. the same should be based on reasonableness and rationality as well as non arbitrariness. It came to be concluded that the state, while entering into a contractual relationship, was bound to maintain the standards referred to above, and any departure from the said standards would be invalid unless the same is supported by good reasons. It is clear from the backdrop of the facts and circumstances in which the impugned order came to be made and the terms and conditions set out in the impugned order that it was not a tapping contract simpliciter which was intended to be given to the second respondents. The second respondents wanted to be assured of regular supply of raw material in the shape of resin before they could decide to set up a factory within the state, and it was for the purpose of ensuring supply of such raw material that the impugned order was made giving tapping contract to the second respondents. It was really by way of allocation of raw material for running the factory that the impugned order was passed. The terms of the impugned order show beyond doubt that the second respondents were under an obligation to set up a factory within the state, and that 3,500 metric tons of resin which was permitted to be retained by the second respondents out of the resin extracted by them was required to be utilized in the factory to be set up by them, and it was provided that no part of the resin extracted should be allowed to be removed outside the state. The whole object of the impugned order was to make available 3,500 metric tons of resin to the second respondents for the purpose of running the factory to be set up by them. Thank you.